virtually all of.
I'm nearing the end of my
that
remarks,
standard.
and I recognize the last time we had a hearing, the chairman broke the rules and violated the rules of this committee to try to silence
I don't want to do that,
speaking.
but I want you to.
And I understand why you interrupt me in the middle of this email, because it is so extreme that I recognize, Mr. Chairman, you don't want the American people to hear what's in this email.
I have, without objection, put into record everything you've asked. I'm not afraid of what you're going to say. I'm just wondering if it's going to come to an end soon.
It's going to come to an end soon. It would have been sooner without the interruption, but it will come to an end soon. And now that we're at it, I would ask unanimous consent to enter this email into the record.
Without objection.
So, describes a disturbing spike in harassment, intimidation, and threats of violence. Now, you spent a long time as a judge when you have three things listed. Am I correct that anyone interpreting that, reading it, would conclude that harassment and intimidation are something different than threats of violence, given that you listed each of the three out separately? Is that consistent with the canons of construction?
The memorandum is addressed to professional prosecutors.
I asked you a question, not who it was addressed to.
Senator, at least let him respond.
No, not when he answers a non sequitur. If
he
wants
may
to
respond.
answer okay, you're taking my time now. This is not coming out of my time.
Listen,
when I ask a question,
we've given you more time than any other senator.
Mr. Chairman,
now listen,
when I ask
all I'm asking is allow him to respond.
Mr. Chairman, when I ask a question, he can answer the question, but he's proceeding to ask a total non sequitur. I asked about the canons of construction on the board.
Please let him respond.
I'll ask the question again. The opening line of the memo specifies harassment, intimidation, and threats of violence. Is it correct under the ordinary canons of construction that a legal reader would understand that harassment and intimidation means something different from threats of violence? Is that correct?
A legal reader would know.
Ask unanimous consent that both of these articles be entered into the record.
Without objection, thank you very much, Senator, for your comments on favorably reporting the nomination.
Mr. Chairman, I'm not completed.
I'm sorry. How much more time do you need?
5 to 10 minutes. As I said, I wanted to talk about Myrna Perez.
She has the nomination before the committee.
Yes, that's what I'm prepared to talk about right now.
I hope that Senator will be mindful of the other senator's time when he uses his own.
Well, I am mindful of the other senator's time. I'm also mindful that this committee spends a ton of time on things like amnesty and not time on doing our jobs. So this committee doesn't have time to look into allegations of racism, doesn't have time to look into allegations of participating in Chinese communist propaganda, doesn't have time to look into the Biden administration releasing thousands of illegal aliens with COVID, but we have time to move political activists forward to satisfy the partisan interest of Democrats in the Senate. Let's talk about this judicial nominee.
Hate crimes and extremism.
Ms. Clark, you know you're testifying under oath here.
Please allow her to.
You just said
Senator
a moment ago.
Senator Cruz, please allow her to complete her answers.
Well, I'm not going to allow her to filibuster, so I'm going to ask a question. If she wants to answer the question that I asked, she can do so, but I'm not.
She should be allowed. I hope you'll show respect to the witness.
I will show respect to every witness, but we also have limited time, as you're aware, and you've been on this committee long enough to know that witnesses, in avoiding questions, will try to filibuster on different topics. So I'm going to ask questions, and I'm going to expect answers to the questions I ask. And I understand the chairman wants to jump in and defend the witnesses, but that's your prerogative to try to do so.
I will defend witnesses on either side and members on either side. We will be respectful in this committee. I hope that all members will.
I hope and expect the same standard will be applied to senators on both sides.
Senator Cruz?
Mr. Chairman, I want to address the issue that is being discussed, which is
the ID Act?
No, how the committee conducted itself on Vinita Gupta.
I'll stay here as long as you wish to do that, but shouldn't we, the business of the committee now pending is S-632?
I was waiting to speak, and I would like to speak on this topic.
You're right.
What transpired with Vinita Gupta, I haven't served on this committee as long as Senator Leahy has, but I've served on this committee for 9 years, and I have seen multiple chairmen hold that gavel. And until a couple of weeks ago, I had never seen a chairman from either party, Democrat or Republican, blatantly violate the rules. The chairman is a very talented lawyer. The chairman knows how to read the rules. Rule 4 of this committee provides that debate shall be terminated if The motion to bring the matter to a vote without further debate passes with 12 votes in the affirmative, one of which must be cast by the minority. That did not happen. The chairman instead asserted the power to end debate, notwithstanding the rules. Now, the chairman has pointed to the fact that when the Republicans had a majority on this committee and the Democrats invoked the 2-hour rule, that the Republicans acted to counteract that, and that is true. Under Standing Rule 26, a majority of the committee can set a time certain to vote, and so with Justice Amy Coney Barrett, we did that. Democrats were strongly opposed to Justice Barrett and were using every procedural tool at their disposal to resist her confirmation, as is their right. And the chairman of the committee followed Standing Rule 26 to set a time certain. Standing Rule 26 requires a majority. The challenge, Mr. Chairman, as you know, is the Democrats do not have a majority on this committee. This is a 50-50 Senate. The Republicans don't have a majority on the committee. I recognize that may make life more frustrating. Your justification was you didn't know that the Republicans were going to invoke the 2-hour rule, and that was frustrating to you. Well, Mr. Chairman, I'm sorry you were frustrated. That does not justify blatantly and cavalierly violating the rules of this committee. And all of us have been chairmen of either committees or subcommittees. A chairman's gavel has some authority, but it doesn't make a chairman an emperor. It doesn't give the power to violate the rules. Now listen, neither side, when we're in the minority, invokes the 2-hour rule often or cavalierly. The reason the 2-hour rule was being invoked on Vanita Gupta is every Republican on this committee believes she is a radical nominee who was beyond the pale, who had embraced and advocated abolishing the police, and we felt strongly about it. Now, I recognize the Democrats on this committee disagree, and that's why you voted to confirm her. That is your right as well. But the members of this committee, this is not simply a matter of, well, there was disagreement, and I'm sorry it happened, but, can't we all just get along? The members of this committee have a right to know that the chairman of the committee will be bound by the rules and will actually follow the rules that are written. And if you don't like the rules, there's a process for changing the rules. But simply ignoring the rules is not a conduct that should be expected or acceptable for the chairman of the Senate Judiciary Committee. And that's what occurred with Vanita Gupta. I appreciate that, but our time is limited, so if you could answer the question I asked.
It's only fair to allow her to complete her answer.
Mr. Chairman, I understand that she has things she wants to say, but I asked if she supports the repeal of RFRA. That's not the question.
Senator, if you want to make a speech, you may make a speech.
I'm asking a question. I'm asking a question, and she's giving a speech, and I understand that you support her nomination, so you're giving a speech too. But I'm asking a question.
I'm asking you to allow her to answer.
She was not answering. She's welcome to answer the question. The question is, do you support the Equality Acts repealing RFRA's protections of religious liberty for Americans?
Senator, I support RFRA. I have enforced provisions of RFRA, and the Justice Department must enforce the law. The Justice Department enforces religious liberty and protects it. It also enforces our nation's anti-discrimination laws.
Let me try a third time. Do you support the Equality Act's repeal of RFRA's religious liberty protections?
Senator, if confirmed as Associate Attorney General, my duty will be to enforce laws to protect religious liberty and the anti-discrimination laws that the Justice Department
Okay, so you're declining to answer that as well. Let's, Mr. Chairman.
Senator Cruz.
Well, I appreciate the sentiments of comedy and bipartisanship and the bipartisan lunch, but I want to take a minute and reflect on an aspect of how this committee is proceeding that has not reflected that spirit. The chairman is aware of my concerns and the concerns of a number of members of this committee, that the way the Judiciary Committee has proceeded in the year 2021 has broken with past practice and broken with past norms on this committee, and has done so in a way that has been partisan and has undermined the important role of the Senate Judiciary Committee. As you know, back in March, when Vanita Gupta was before this committee, Chairman Durbin chose to break Rule 4 of the committee, which states that it takes a majority vote, including one vote from a member of the minority, in order to bring debate to a close. That had no precedent in the history of this committee. We then saw yet a second opportunity concerning Toby Heitens, nominated to be a judge in the Fourth Circuit Court of Appeals, where the total questioning for that lifetime nomination to the Court of Appeals was 18 minutes, even though my staff and the staff of another senator have both conveyed to the chairman that we were en route to the committee for the hearing. The chairman gavelled down that hearing after just 18 minutes of questions. And then sadly, we saw this pattern continue again just recently, just last week. Just last week, the committee held a hearing for Elizabeth Prelogar, the nominee to be Solicitor General of the United States. Solicitor General is one of the most important positions in any administration. Solicitor General is often referred to as the 10th Justice. And yet, the hearing this committee held for the nominee for Solicitor General allowed precisely 20 minutes of questioning. After the debacle of the nominee for the judge for the Fourth Circuit, Chairman Durbin told this committee that he intended to conduct things differently, to actually have some acknowledgement of comedy. 20 minutes for a Solicitor General nominee, and I would note that hearing was held not only at the same time as multiple other hearings of committees, and every member on this committee serves on multiple other committees, and so you have to be in multiple committee hearings at the same time. That committee hearing was also at the exact same time as a floor vote. So I had fully intended to come and question the nominee for Solicitor General. There were serious questions about the conduct of the Department of Justice in ongoing litigation that nominee is responsible for, and yet 20 minutes, and my staff conveyed to the chairman's staff that I was on the floor voting and intended to come back and raise questions. But before I could physically get back here, the chairman gavelled it down. And to put it in perspective, because I'm getting eye-rolling from the chairman right now, this is wildly out of step with the precedent of this committee, and I'll give an example. In 2001, Ted Olson was the nominee to be Solicitor General of the United States. Ted Olson, the questioning for Ted Olson lasted 3 hours and 37 minutes. At the time, Senator Schumer and Senator Durbin both questioned for 15 minutes each. Senator Leahy questioned for nearly 20 minutes. And here's what Chairman Durbin said at the time after 3 hours and 37 minutes. I want to quote Chairman Durbin. "I do sincerely regret that we have two nominees today because 15 minutes is not enough for posts of this importance to be considered in tandem." Chairman Durbin was right 20 years ago. And this is now a pattern 3 times in a row of running roughshod over the rights of this committee to question nominees. And listen, I recognize there's a Democratic majority, the barest majority humanly possible, but there is one. But the conduct of Chairman Durbin is wildly out of step with the conduct of Chairman Leahy before him, with the conduct of Chairman Graham before him, with the conduct of Chairman Grassley before him. And there will come a time, particularly for the new members on this committee who have not yet had the opportunity to serve in the minority on this committee, there will come a time when the gavel is on the other hand. And so the fact that a Democratic chairman can ramrod through partisan proceedings 20 minutes objectively is grossly inadequate for a nominee for Solicitor General. And this committee has always had vigorous disagreements when it comes to questions of policy and law, but we have not seen chairmen playing games to protect partisan nominees, and I think that does real damage to the ability of this committee to function effectively.
The chair would respond. It is not within my power to determine how many senators attend this hearing and the length of their questioning. That is up to the individual senators to make the decision. If there's an important witness, they have ample opportunity to come and ask questions and even ask for a second round if it's appropriate. I can't control that, and I'm not going to set a timer and say, well, it'll be 1 hour for this witness and 2 hours for the next. The second point I want to make is somewhat personal, but I want to make it clear to every member of the committee. You raised this point once before, that you were, quote, on your way, and I closed down a hearing. I went up to you and right in that corner and stood and said, I'm sorry, I didn't realize that. It'll never happen again. Now, let me tell you what happened. I know you had staff present, but let me tell you what happened when I heard in this last hearing that you might be coming. Senator Cotton finished questioning, and when he finished questioning, I was told you were, quote, on your way. And then I turned to your staffer, and I don't want to cause any problems there, and said, where is he? She said, I don't know, but I think he's on his way. We waited and still didn't hear. And at that point, I said to Senator Cotton, what do you think I should do at this point? On the record, he said, I don't want to comment on that. I really tried my best to give you an opportunity, but I think it is unreasonable for any member to say that the Senate Judiciary Committee and staff should wait indefinitely on the possibility that a member returns. When I left and went down the hallway, you were not on your way, at least not at that point. I'm going to do my best to leave the meetings of this committee open so that members have an opportunity, and I will, any good faith effort to get here, I'm going to try to honor. But you have to at least honor the members of the committee and staff by telling us where you are and when you're coming. The sitting here indefinitely waiting for the possibility is not fair to the rest of the committee.
So, Chairman Durbin, if I might respond to that.
Certainly.
I'll respond in 2 ways. Number one, with the nominee to the Fourth Circuit, when I arrived, and Senator Hawley also informed your staff that he was coming, both of us were in the elevators rushing to get here. When we got here, there were not one, there were 2 Democratic senators sitting in the anteroom, neither of whom had questioned, but were happily sitting in the anteroom and, in fact, were laughing. It has the appearance of simply game